So today on Thursday, the U.S. Supreme Court came down with a major ruling on gun rights. It's being called one of the biggest Second Amendment victories in the last decade. What can you tell us about this ruling?
Well, I think one of the first things that both sides in the gun debate have to realize is that this is a pretty limited opinion. This is not answering all the questions about what sorts of guns can be prohibited and what kind of process do you have to go through. Really, the only thing the court holds today is that if a state has a law that says nobody can be sure of their ability to carry a firearm outside their home unless they convince a government bureaucrat that they need it, that violates the Second Amendment right. And the court decides that today over a very strong three-justice dissent. But that's really all they decide. And so many of the questions that were left open after D.C. versus Heller in 2008 and McDonald versus Chicago in 2010, they're still open today. We haven't solved many of those.
Yeah, and it's important to note that because in these situations, there's a lot of panic, on both sides, right? One side in this case might be rejoicing, the other side might be panicking, and really maybe neither of those reactions are entirely accurate to the full scope of what, not that there's not a reason for some to be elated in certain cases, but they're more complicated. There's more details to hash out, as you've just mentioned. But let's talk about this proper cause requirement that New York had, because this may be foreign to other people in other states around the country. What was it? If I wanted to go and get a concealed carry permit, what did I have to prove exactly to the New York government?
Well, that's a really good question. And the fact that it's hard to know the answer to that question was part of the problem with the law. 43 states in this country have what's called must-issue laws, that if you meet the criteria, if you jump through the hoops, then the government has to give you a permit to carry your gun. But these are unusual. We call these the may issue laws. And New York's law basically says, even if your background is clean, even if you have no criminal offenses and nobody's alleging that you have mental problems, even if everything is good, you still have to convince someone in the government that you have some special reason, some special need to have a weapon to carry it outside your home. And if you can't convince them of that, you just don't get it. And of course, this leaves itself open, and I'm not saying it would necessarily be applied in an unfair way, but you could imagine situations where how much money you have and who you know and whether you're famous and all these things could play in to someone deciding whether you get to carry a weapon because there's no legal standard. It's just if the government decides that you need it, then you're allowed to have it.
Well, and that makes you wonder, and I have no data in front of me right now to make a definitive proclamation, but after a mass shooting or an event happens and there's a lot of panic, does that affect the ability of people to then go out and do this? Because if the rules aren't nailed down and solid and we don't understand what those parameters are for this, basically it amounts to a special treatment, which a lot of other people would say, and the Supreme Court seems to say today that this is actually a right. It's not some sort of special treatment that you need to get with special permission. So it's interesting because some of the reactions to this, President Joe Biden says he's deeply disappointed. New York Governor Kathy Hochul, she called it a dark day in New York State, and talked about, being prepared essentially to go back to muskets. And one of the claims that often is made, and it's an interesting one, is that, the framers, the founders, there's no way they could have ever known that we would develop the types of guns that we have. Therefore, the Second Amendment essentially only applies to muskets. I don't know if you want to speak to that at all. I'm sure you've heard this question come up quite a bit.
Well, it's a pretty silly argument. I mean, it's basically like saying freedom of the press only applies if you're writing with on parchment with a feather quill. That of course the courts have to take rights which have meaning from when they went into the Constitution, and they have to apply them to a different world. They have to apply them in changed circumstances. And to say that the First Amendment applies to websites and emails, and the Fourth Amendment about unreasonable searches applies to emails and those kind of things, doesn't mean you're changing the amendment or its meaning. You're simply applying that context to today's world. So, to say, oh, well, it only applies to weapons that were physically around in 1791 is a pretty silly argument. And the court deals with that very, very directly. And they say, not everything is a perfect analogy. This isn't just an easy color by number kind of exercise. We're going to have to try to figure out the content of that right and then apply it in today's world. And they make no effort today, as I said before, to draw all the lines and to tell us exactly what the limits are. They simply say a regime that gives you no way of knowing that you can carry a gun, even if you're perfectly clean in your record, whatever else might be okay under the Second Amendment, that isn't.
Well, and it's interesting, too, because when you dive into the history, and I'm by no means a firearms expert or historian, but there are some things you do stumble upon. Joseph Belton, who knew Benjamin Franklin, he had appealed to Congress, offered to the Continental Congress a new technology that he had apparently developed in 1777. So this is well before the ratification of the Second Amendment. And he called it rapid fire muskets. He talked about being able to develop these rapid fire muskets that would discharge 8 balls, one after another, in 8, 5, or 3 seconds of time. So my only point there is it's very clear that there were people alive, and not only people alive, but people interacting with founders and framers of the country who knew that there was going to be other technology. Now, we can have that debate all day long, but I think what you just said gets around all of that when it comes to the First Amendments and some of the other rights that we enjoy and how we apply that to the modern era that we're in.
The dissenting justices are very passionate about this. Very long opinion by Justice Breyer. And he's talking about all the school shootings. He's talking about the people who commit suicide with handguns. And I think he's correctly challenged by the justices in the majority by saying that may all be true, and those are all real problems. And none of us like it that there are school shootings and that there are, mass killings. But the question of whether a law-abiding New York citizen may carry his handgun out of his home has nothing to do with whether there will be school shootings and whether someone could commit suicide. If people who commit suicide with their handguns typically do it in their own homes, it doesn't matter whether they can carry it out with them. So all these other societal questions that we're all wrestling with, right? Whether you're pro-gun or anti-gun or sort of agnostic, we live in a tough time. But this case really doesn't get into any of that. This case, because its holding is pretty limited in simply saying you can't stop people from carrying it all, it leaves a lot of that open that still will have to be decided in the future.
Well, listen, I so appreciate your time and thank you for coming on, breaking this down for us. It's complicated and it requires this sort of discussion and distilling, so we appreciate it.
Always my pleasure.